Hey everyone, welcome back to Allegedly, the show where we talk about all things law. I'm Elise.
And I'm Samantha. This week's episode is allegedly illegal. Let's start with a few common legal questions. Is it actually illegal to eat while driving? What about driving barefoot? Can you get in trouble for that? And lastly, can you wear AirPods while driving, or is that also against the law? The answers might surprise you, but we'll get into that later.
In this episode, we will discuss case law. Paige, can you describe what that is?
Case law, or common law, is law created by judges through court decisions in individual cases, which establish legal precedents that guide future rulings. Courts use precedents to interpret and apply the law, helping to clarify and change the law over time.
Thanks, Paige. Now that we understand what it is, let's look at some of the most famous examples. We had the opportunity to talk to Officer Barrington and Officer Kelly with the Allen Police Department to find out how patrol officers use case law on a day-to-day basis.
Today, we'll talk about three cases: Terry v. Ohio from 1968, the Carroll Doctrine from 1925, and Texas v. Brown from 1983.
Ivy, the floor is yours for Terry versus Ohio.
So imagine this. A detective in Cleveland, Martin McFadden, sees three men pacing back and forth in front of a store talking to each other. He suspects that they're planning a robbery, so he approaches, identifies himself as a police officer, and then pats them down, and he ended up finding a concealed pistol on Terry and another one of the men. The court issue was whether the weapons that were found violated the Fourth Amendment's prohibition against unreasonable searches and seizures. In Terry v. Ohio, the court ruled that officers are allowed to stop and pat down, also known as frisk, if they have reasonable suspicion.
Hold up. What is the difference between a frisk and a search? Layla?
A frisk is a limited outer clothing pat-down for weapons when an officer has reasonable suspicion that a person is armed and dangerous, while a search is more extensive for evidence that typically requires a warrant or consent, and it's just a broader scope beyond just weapons. The core difference lies in their purpose. A frisk is for officer safety, whereas a search is for contraband or criminal evidence.
Adding on to what Layla just said, the court emphasized that the primary purpose of a frisk is to protect the officer and others from potential harm by detecting concealed weapons, not to search for evidence of a crime. Terry v. Ohio created a legal basis for police to conduct investigative detentions and pat-downs when they have reasonable suspicion, which was previously lacking.
Ivy, that was great. Now we're going to talk to Alexis about the Carroll Doctrine.
Picture the Prohibition era where alcohol was illegal. George Carroll was driving when officers recognized him and his car from a chase that had happened a few months prior. The officers stopped the car and checked in plain view for any alcohol they might be smuggling in the car, but they found nothing. They opened the rumble seat, which is the back seat of an old car, and saw nothing, but felt the leather was harder than ordinary. The officer decided to rip the leather, exposing almost 18 gallons of illegal liquor without the consent of the driver or a warrant.
So, what was the outcome of the trial?
George Carroll, the driver, argued it's unconstitutional under the Fourth Amendment because officers didn't have a warrant to search his car. The Supreme Court ruled in favor of the officers. While officers still need probable cause, the mobility of vehicles creates an exigent circumstance that allows them to conduct a search without a warrant, meaning the search must be immediate.
Alexis, that was beautifully said. Moving on.
You think you know Texas versus Brown? Think again. Aspen is here to shake things up.
In 1983, a police officer stopped Clifford James Brown during a driver's license checkpoint and asked to see his license. While searching, Brown dropped a green party balloon on the passenger seat. The officer sees this and also notices other drug paraphernalia, including vials and loose white powder. Brown informs the officer that he does not have his license and complies when asked to exit his vehicle. The officer picks up the balloon from the car and sees a powdery substance inside. Brown is then arrested.
So, was that a violation of the Fourth Amendment?
It actually wasn't, because the officer saw everything in plain view, and while the balloon itself wasn't immediately suspicious, from the officer's previous experience with drugs and arrests, he knew that that was often how drugs were carried and concealed, and given the other items in the car, he easily could determine that it was in fact drugs.
Thanks, guys, for all that information. While those are all nationally recognized cases, let's get more specific with some Allen City ordinances.
So we're going to go through some scenarios that a patrol officer might encounter on a shift. And as we talk about them, you guys are going to say whether or not you think they're arrestable offenses.
So there's a house in Allen that houses a known drug dealer. The house has people coming in and out of it through the front door. There's a tree blocking parts of the house where the house numbers aren't being shown. Could you arrest for not seeing numbers on a house?
Of course not. Why would you? It's just numbers on a house. And also, you can use other house numbers to figure out what that number on that house is. So I don't think it's that big of an issue.
Well, actually, in Allen, you can arrest somebody for their house numbers being blocked.
Next, you're an officer and someone is stopped at a drive-thru complaining about their order being messed up. It is now blocking the entire lane. They continue to sit there for 30 minutes complaining and trying to get their money back. This hinders you and the long line behind you and making you stuck. What do you do?
So I probably would arrest as an officer just because they are kind of creating like a commotion and everything. Um, and so I would just get them out of the drive-through so then things could take place as normal. But I also probably would have them like talk to management or something with the place so they could get their money back or at least get their food.
That is correct. In Texas, you can arrest for obstructing a passageway.
A girl walks to school every morning, but there's no sidewalks along a stretch of the road. To stay out of the way of the car, the girl chooses to walk on the right side of the road with traffic coming from behind.
I personally don't think people can get arrested for that. I feel like I would actually check up on the person instead of arrest them because I mean she's not blocking any traffic, so I don't see a sense of why she should get arrested for that.
So actually, that is an arrestable offense, or you should just tell the person who's walking to walk on the opposite side of the road so that they can see the traffic coming towards them.
So, let's look back at our 3 questions from before. Is it legal to eat while driving, to drive without shoes, or to drive with AirPods?
Yes, all of those things are legal to do, but you just have to make sure you do them safely as to not be a danger on the road.
Moral of the story, case law affects your life too.
So stay curious.
Stay informed. Stay allegedly.